my practice.
No worries.
All right, thank you.
9 a.m. Let's see. Oh, we've got
Rise
already.
and shine.
You got already people. It's up coming up. If you could see the on the bottom, the participants.
You know, I can't. Oh, okay, I see it. I
You
see.
see they're joining now.
Yep, yep.
Good morning, anybody who's joining us. Good morning and welcome. I guess haven't been able to do this for a while for a million reasons. So very happy to see whoever is joining us. You guys see us, as you know. We don't see you. So
Maybe that's a good thing.
a good thing.
You know, I've had people I know that like dress from up here up, but you know, waist down, it's sweats and whatever.
That's the pandemic normal, right?
Yeah.
But everybody, as you're joining us, I do have to make a couple of technical announcements. So I'll just wait. We'll wait, 5 minutes for at least the first portion that our technical vendor is asking me to remind everyone. In general, as we're speaking already, the 25 we are on, we are, you have the chat box, and Jill, you prefer we do Q&A while you're speaking, right?
Yeah. Like, I'll tell you guys, like, ask the questions. Most likely, if you're thinking it, other people are thinking it also. So, Avi, you read the chat, the questions for me.
No worries.
And, if you were in front of me, I'd love a dialogue. So let's do it virtually.
Yes. So we'll everybody who is joining in, we'll also wait. We'll wait so everybody can hear. I see 30 now. Welcome. This is Signature Bank hosted CLE. Good morning and welcome again as you're joining us. Nice to see you all. It's been one of those crazy mornings. I started at 6 on the computer.
Yikes.
Yep.
Well, I will tell all of our audience that is, that's listening now, and maybe we can do it when I end, but I teach at Cornell Law School, and the students are going to be putting on 3 seminars/webinars. There will be opportunity for any of you guys to refer yourselves, your family, your friends. It is our public service to not only the Ithaca community, but now because it's webinar, it's an outreach to everybody. Students are going to be putting on the basics of estate planning, and the bonus is that anybody that attends will get a free living will and healthcare proxy. We'll get the forms, and the students will help prepare them, and no cost to join. It's again part of our big pro bono effort, and if anybody's interested, speak to Avi. He'll have all the details and he'll hook you up. So
happy to do it.
Students. Part of their job is they got to market this thing. So
very happy to do it. So let's see where we are at 9:03. People are still joining in.
Okay.
So I'll give you probably a couple more minutes before I start with some of the important. I know you didn't come to hear me, obviously, but well, that's the price you pay. So
for those that are tuning in, make sure you guys have downloaded the handouts. We'll talk about it. It's on your screen. We're going to be referring to them, and these handouts are not only going to be helpful for our talk today, but I'm hoping that you guys can kind of use them for your own practice, or share them with people that need it as you encounter them. They're I authored them, but they're also very helpful.
Yes, and make sure, please, all the people who join us again. When you entered through the attorney's credit registration website, which really shows our logo, the bank's logo, you have a section there. Whoops. You have a section to download Jill's material. It was done in one PDF according to them, so it should be pretty easy. see how we're doing on time. So it will be fair for everybody's time. So I guess it's about 05. So I'm just going to start. I know we have over 50 people already. Fantastic. For those of you who don't really know my pretty face, my name is Avi Azulai. I am a senior vice president and a group director for commercial banking at Signature Bank. I manage a group of bankers who handles small to mid-size firms. A lot of you guys know me as working with the law firms, legal industry for many years. That is still the case. The difference, I would say, what we've added at Signature Bank is the fact that I have freedom to bank firms in any other industries. What we do very well is using our single point of contact model, which means the clients' work, products, services are given to them via the group, via us. No need to go to different areas as in all the other banks. So this is a little bit about how we work. And then, as I mentioned, our group also has the growing business of international clients. It's growing fast the last few years. And so any clients that you may have that you're having, you probably will have issues with getting firms, foreign and American firm, foreign owned, to get accounts. Reach out to me. It's something we know how to do well now, and we're doing it remote. So about Signature Bank, a couple of lines. You may have seen us in the news now. Signature Bank is really 21 years old and amazingly grew so fast that I think most of the Wall Street community is watching us now. We are part of the S&P 500 as of 1/1/22, which is a great honor to be. More scrutiny for us, but that means we're doing something right. The bank is operating now in New York, where we started, California, San Francisco, Los Angeles Metro for now, North Carolina in 2 centers, Connecticut. We are doing that via 40 offices, what we call financial centers or financial hubs, and include full servicing with branches. And the bank has now reached, at the end of 2021, we've reached close to $120 billion in asset, almost $8 billion in market cap. So this is about the bank. We'll move quickly to why you're all here. You're here to hear Jill Miller, my good friend Jill Miller. The topic of her course is a primer on New York probate process and estate administration. So who is my good friend Jill? Jill is the principal of Jill Miller and Associate PC. She focuses her work on formulating sophisticated and highly personalized estate planning for individuals and families, with the objective, of course, of minimizing estate tax. She's also an expert in estate matters affecting non-US citizens and non-traditional families. And Gina and I have worked on cases where you have to include Sharia law, et cetera, very interesting, very wide knowledge that Jill has worked in and working and representing families from around the world. Jill has founded her firm in 2004 after working for over a decade in the area of trust and estate law. She's a fellow of American College of Trust and Estate Council, a frequent lecturer on estate planning, both private and public symposia. She has presented courses sponsored by the American Bar Association and the Division of Tax, the New York Bar Association, Financial Planning Association of New York, and so on. Jill is currently the director of Estate Planning Clinic and adjunct professor of law at Cornell Law School, and is teaching trust and estates for a while, as well as taught at Fordham Law School since 05. Jill is AV permanent peer review rated by Martindale Hubbell and is named as a super lawyer year after year. And without further ado, we will start with Jill. Before Jill, you get it, I just want to remind one message from our host. Don't forget, when you close the webinar at the end, you need to get out of it and go to what's on our hosting page called the tab called Enrolled Webinars and click Get My Certificate in order to get the certificate. Now, another technical issue, as you recall from the past, I'm going to inject 2 codes. You got to write them down in the beginning of the course. At the end, you will need those codes in order to receive certificate. Just want to make sure you're not sleeping on us, right? And
I'm going to do my best, okay? I'm going to do my
other
best.
than that, Jill has suggested, for those of you who started early, that you can ask the question throughout as she starts. It's going to be on the chat. You could type it in as we've done in the past, and I will try my best to ask her, stop her, so on and so forth. It should be done in about an hour and a half. Jill, take it away.
Great, thanks. And we're going to be taking a break in the middle. Is that right?
Well, maybe not if you want to just go through it.
Okay.
But we haven't done. It's much better.
Okay. All right. Sounds good. We'll plow ahead. All right. Well, it's great to be here. Thank you for that very lengthy introduction, Avi. I think the only person would have enjoyed that was my dad. I wish I had him plug in. But anyway, it is great to be here, guys. This is, as Avi told you, a primer on New York probate process and estate administration. Everybody, if they haven't already, should have downloaded or have access to 4 handouts. That is something I'm going to be referring to. These handouts are something I authored and are really meant for you. I mean, I use them for my practice. When I started out, I saw needs for the clients and to make the process easier, especially for client communication, and I authored them. So they've been meant to share. And I also use them at my class at Cornell. The first one is estate administration milestones. And that is like the 10,000-foot view of what this process is. Like, clients will come in with this like Hollywood version of what estate administration is, or have heard, stories. My favorite is always that I'm going to date myself, that scene from Rain Man, was it with Dustin Hoffman, and anyway, they're in the father dies, and they're in the lawyer's office, the wood panel's office, reading of the will, and then the next moment, the beneficiary, Tom Cruise, is like driving down the street in the car, and the disabled brother inherits everything, and people come in with these unrealistic viewpoints. That has never happened. I've never had a reading of the will. Ever. I guess it's one of those Hollywood things. So I drafted this estate administration milestones to manage clients' expectations. And that's one of the big, takeaways for this class, is to manage your client expectations. In fact, one of my things for you is that my goal for each and every one of you guys is that you will remember, get 3 things that will help you, your practice, or your family. These 3 things, but that you will remember in 6 months' time, something that will really, really stick. So 1, estate administration milestones. We'll go over that in a little bit. 2, a checklist of people and places to call upon the death of a family member. Really, I've gotten a lot of client feedback, very, very helpful. People's, heads are spinning when they, lose somebody. Even if it's expected, it still is unexpected. And it is a list to say who you need to call and when, broken down in time slots. The old estate administration checklist. This is going to be a good handy dandy form for any of you that practice in estate administration or thinking about it, or if you are ever involved with an estate and you're the client side. This gets you organized to what to bring to the first meeting. One of my favorite adages is time is money, right? So if you can get organized and save time, when you go in your lawyer's office, your clients can save time. They can also save money, and people always like saving the old money. And then there's just like a little from Hot Docs, a probate petition. We'll go over that. So please, hopefully everybody has downloaded that. Again, my goal is three things that you're going to remember in 6 months' time. First, and I'll talk about red flag moments. Like red flag moment, that's something that to raise your attention. Maybe if you have an iPad to jot it down, or an old-fashioned piece of paper, some important takeaways as we talk today. But one of the big ones here is you manage your client's expectation on timing of the estate administration. Especially crucial right now, guys, because of COVID. If I was able to do live and I could say, who here has had terrible experience with the courts and the amount of backups? Everybody been raising their hand. In the best of times, pre-COVID, it could take 2.5 to 3 years to finish an estate administration. And be like, what? That's for a taxable estate, I should say. So that's when you're going to be filing an estate tax return. And a very key takeaway, taxable estate does not necessarily mean you pay taxes. It means that your gross estate has hit the filing threshold that you're required to file taxes. Biggest example is when I have a married couple, husband dies first, survived by the wife. Say we have a $10 million estate, it all goes to the wife, even though there's no estate taxes, because it all goes to the unlimited marital deduction. You still have to file. Okay. And why do I have the husband die first? That was my favorite law school jokes. Why do husbands die first? If they want to, but okay. All right, fine. So, we're looking at a time period of 2.5 to 3 years, mostly because of the waiting for the estate tax closing letters for New York and federal. So, you'll have periods of activity in the beginning, and then periods of waiting. And typically what I'll see is in the beginning when someone is gone, we have the people and places called upon the death of a family member. There's a lot of activity. We're getting the will together. We're getting the paperwork together. We're probating. We're marshaling assets. Getting those letters testamentary, which we'll talk about. Then the middle period is kind of evaluating assets. Sometimes it takes longer to collect assets, negotiating claims, getting everything prepared for the estate tax return. So valuations typically take a long time, especially if we have like hard to value assets like closely held businesses that can really hold things up. And then we'll have busyness at the end when we're pulling it all together, filing the estate tax return. And then we go into another waiting period, waiting for the estate tax closing letters. And then we'll do our final distribution with the accounting. So again, if it's a taxable estate, meaning that you have to file estate taxes, we're looking at 2.5 to 3 years. Right now, in the pre-COVID days, I'd get my probate done, I don't know, 8 weeks, 6 weeks, sometimes sooner. These days, we are looking at months. So make sure when you have a new estate, you tell those clients, hey, I just want to let you know, and it's not my fault, because they always want to blame the lawyers, right? Yeah. The courts are really, really backed up. So when we file, if we even talk to somebody or someone's even there, we'll try to get an ETA. A lot of us now switch to online filing. So, it's just, you'll call the court, maybe you'll get somebody, maybe you won't, but manage the client's expectations. I always say better, under promise and over deliver. Then you look good, right? Okay, so let's now turn to our first handout. And just before we get into the details, let's look at the overview, okay? The estate administration milestones. That's our 10,000-foot view of everything. So part one, and here, that's what it looks like right here. Part one, preparation for the meeting with the estate attorney. You're going to gather all the information to probate the will, or if there's no will, you're going to petition for letters of administration. And we'll talk about who is entitled to petition, okay? And so we're going to prepare that. Then we're going to have the initial meeting with the estate attorney. You're going to bring your original will, the death certificate, bring the family tree, and an estimated inventory of assets. That's very key. We want to have an idea of one, do we have to pay any estate taxes? Very, very important. And two, what kinds of assets there are. So in our inventory, we're going to describe the decedent's interest in each asset. an estimated value, and is it jointly owned or a designated beneficiary? So this is this is a big red flag moment, guys, okay? How we pass property, what is under the control of the executor? So one of the, in the olden days, everybody, controlled everything by a will. With the rise in the last, I guess 100 years or so, maybe a little bit less, we have the increase of what I call will substitutes. Will substitutes are assets that pass by operation of law to a joint owner or a named beneficiary, okay? In some ways, some families can have all of their assets by will substitute, meaning that on the death of the person, there may not be anything for the will to probate. Another way to say it is that a will is really a safety net. It is the catch-all. So if we don't know where an asset goes, because it does not have a joint owner or a named beneficiary, my will control it. Those are my probate assets. So we're doing our inventory. Again, very, very, a very big key here. We're going to look to see what assets are probate assets and what assets will be will substitute assets that pass by operation of law. So if you're all in front of me, I would say, okay, guys, name my will substitute. But sometimes if I'm, being in a really fun mood, we'll play a little game of Family Feud, and we'll list top 8 will substitutes, and we'll see who can name them all. But since we can't do that, we'll just talk about it. So we have our bank accounts payable on death, transfer on death. We have our securities accounts with JTWROS, joint tenant right to survivorship. We have our real estate tenancy by the entirety. And don't forget our retirement accounts. We have our IRAs, our 401ks, our 401(b)s, our annuities, all passed by beneficiary designation. And then, of course, we have our super duper will substitute, our revocable trust. And any assets that are in the revocable trust will pass by the terms of the revocable trust. So basically, at the end of what we just talked about, you can kind of see that if we want to, we could have almost all of our property pass outside of probate through will substitutes. I will say that probate these days is getting more and more gummed up because of COVID. And there are states such as California and Florida, which has had longstanding traditions to avoid probate because their particular systems are known to be difficult and time-consuming and onerous. And that has given rise to the revocable trust, which we'll talk about a little bit later. So back to administration milestones. We're making that inventory of assets. We're figuring out what are will substitutes, what are probate assets, because our probate assets are controlled by our executor. And that executor will also get commissions on them unless the will directs otherwise. Or if it's an estate administration, again, commissions on that. Any asset passed by operation of law, who's responsible for it? Is the executor? The executor responsible for it? I would have to ask you, I'd say, who in the audience say the executor is responsible, and if the beneficiary of the IRA calls up, or the payable on death person, oh, lawyer, can you help me? What's the answer should be? The answer should be, no, I can't help you. I'm not supposed to help you. That is your asset, it is your responsibility. You need to collect it on your own. Certainly, I don't want to be a pain to people. I give, you share the death certificates, the paperwork that they need, but it's actually really not appropriate for my executor to have the lawyer spend legal fees on helping beneficiaries collect will substitutes, because that is taking money out of the residuary estate, and that is who the executor, that is their job to do, and their fees are paid out of the residuary beneficiary. Okay. We've met with our lawyer. We have we've also had our estate administration checklist, which we'll talk about in a moment. The lawyer is then going to file a petition with the surrogate's court and obtain letters testamentary if there's a will, or letters of administration if there's no will. That's your certificate with the raised seal. A little red flag moment here when you are applying for your letters testamentary or letters of administration if there's no will. take a look. Better to over pay, get extra certificates than less certificates. And the way you figure out, you take a look at all the assets that you have that are probate assets you think they're going to want to get a certificate. They're only $6 each, so it's not a big deal if you buy too many. You don't want to, on the other hand, you don't want to over purchase because sometimes they quote unquote get stale. And if you're going to be collecting an asset and it's sometimes over a certain number of months, they may ask you to go to court and get fresh letters, which means you got to call them up, give another $6 and get ones that are dated recently. Okay. We've got our letters testamentary. We've got our letters of administration. We're going to set up the estate. We're going to get the tax ID number. That's our next step. Opening our state bank account. I have all my bank accounts with Avi, my state bank account. So here's your plug, Avi. He does a great job, and clients are happy. I'm happy. There you go. Okay. Then your executor is going to marshal the assets, collect them, pay all the debts. At the end, you can be filing inventory for surrogates court, and those are estimates. Prepare and file the estate tax return. Normally, I could spend a lot of time on that, but because so many of our estates are now under the threshold, at least for now, a lot of my the tax return work, I do not have as many. If I was live in the audience, I'd say, okay, what's the current New York estate tax threshold? And I would have someone hopefully raise their hand and say 6.11 million, specifically 6,110,000. I'll go, okay, what is our federal amount? And then our federal amount would be $12,060,000. And that is our current exemption amount. And 2026 is the federal is going to be cut in half, which will probably equal about our New York amount. After you file your state tax returns, you'll get a closing letter, and that is taking a long period of time. And now you do have to pay and ask for one, which is annoying for the federal. And then you're going to distribute the assets and close out the estate. One of the key factors there when you're closing out, we have talked about the accounting. Most, let's say, states are settled informally. That's receipts and releases. Very, very rare do I go to court for a formal accounting. Maybe in my entire career, maybe I've done it like once or twice. It is a tar baby. It is something to be avoided at all costs, like traffic. So really worse than traffic, really terrible. All right. So let's go back to that's our an overview of our handouts. So let's talk about the immediate action. So our decedent has died. We are first going to locate and evaluate the will. So where is the will? Okay, most likely, at least in New York, and the tradition changes depending on what state the person's in. Traditionally, the drafting attorney will hold the will in their own vault. That is something that is a industry practice here in New York, and we do that for a couple reasons. One is self-serving, so just throw that out. If the client's original will is in our vault, hopefully they'll use us for the estate administration. But there are other value added for the client as well. Number one is that in New York, we have what's called a presumption of destruction, meaning that if it is known that a client has their original will in their home and it's not found at death, then it is presumed destroyed, which is a really terrible thing. And you can kind of see how this can happen. I mean, people move during their life, and then as people get older and people are sick and there are people in and out of the house, and people are purging things, getting rid of stuff, downsizing. You can see how that can happen. Another reason is that you can have your will in your safe deposit box. And if you have your will in your safe deposit box and the bank finds out that somebody is gone, then what will happen is that the bank will seal the box, and that is a pain to get it open. It's just another process, more paperwork to file with the court. It's not like they will say no, it's just, an extra thing that you have to deal with. And, clients never want to pay for extra things. So I have my will in the vault. I'm now going to evaluate the will. Hopefully, certainly if it's with me, I will make sure I will not do the number one cardinal error. And this is a red flag moment. You get your original will, or if you tell someone or your secretary or whoever gets it to make a photocopy to send to the family. Do not unstaple that will. Do not unstaple that will, because if you do, no, it's not invalid. You have to prepare and file an affidavit of staples, basically saying that I had my original will, or my secretary, or my family member, whoever it is, I accidentally unstapled it and made a copy. The clerks will look at it. They will look to see if those staple holes do not match up, and they will ask you for the affidavit of staples. So do not do that. Okay. Identify your heirs and distributees. Now, who are those? Those are people that in order to probate your will, or in the estate administration, we need to get jurisdiction over them. Well, what does that mean? It means we got to see who would take from the decedent's estate if the person died without a will. So that is based on EPTL 4-4.1. That is our intestacy statute. So, and it follows common sense. So if I have, if you're married and you have no children, the sole distributee is the spouse. They're the only interested party. If you're married and have children, it's going to be the spouse and the children. If you're not married and have no children, it's going to be the parents. And then the descendants of parents, that's siblings, nieces and nephews. Then from there, if you have no parents and no siblings, we're now going up to grandparents on the maternal and paternal side, and their descendants, aunts, uncles, and we'll go down to first cousin once removed. So finding your heirs sometimes can be a hassle, especially if people are estranged from their family. That's where the old laughing heir is. And, when I tell clients, okay, we got to find, I haven't talked to my father or my family for years. They're terrible. That's okay. We can't choose our family. But if in New York, in order to probate your will, giving everything to charity or giving it to your friend or your domestic partner who you want to choose, we're going to have to find those people and give them a copy of your will and ask them to waive and consent. We'll talk about that in a little bit. Okay. We're going to secure the decedent's property after the person dies. What does that mean? It means very often you're going to change the lock, especially if the person died alone. Very often there are caretakers or other helpers coming in and out of the house, getting the mail, getting stuff. When you're an executor, you have the wonderful privilege of being personally liable. That's you, not your company, not your law firm, but you. You mess up, you are personally liable. So changing the locks is generally a very good idea. You're going to secure the car. Pets. If the person lived alone and they had a pet, please, guys, be on top of it. Most likely people will know and make sure that pet is taken care of as the person is gone. Insurance. Red flag moment, guys. You have to make sure your estate, the insurance is up to date. So if it is, especially if someone died and they were living alone, you need to get insurance for the estate. You need to find out who the insurance company is and say, look, the person is not living there anymore. Last thing you want is something happens, you didn't update the insurance, and they have the reason to deny, and you, my friend, are personally liable for that. Oops. I don't know doesn't help. It doesn't work. Now you're going to meet with your attorney. And so let's get out, just have a little closer look at what we're going to bring to the meeting. Okay. So time is money, said that. And you want to make sure, and your clients will thank you for it. And people like being organized. Like after going through all of this stressful stuff with the death of their family member, it gives them direction. And that's helpful because people's minds are very often spinning when this happens. So let's get off the estate administration checklist, items to bring for the first meeting. Some things are going to be common sense, but some things are not. We're going to order 10 to 15 death certificates. Best to do that at the funeral home, because if you have to go back to the well and get them, it is a pain, it is more money, and it's time consuming. They're about, I guess, like $15 each or so. Best to just get a couple extras. Good news, they don't expire like our letters testamentary, so it's always good to have a couple extra ones. And sometimes you find this happens down the road. Like I see this now, husband and wife died, they owned a piece of real estate, and no one ever bothered changing the deed, and person just kept living there because there's no deed police coming in there and saying, oh, what are you doing in this house? And this house was belongs to someone that died a long time ago. As long as the property tax are being paid, no one's really going to get into anything. And so sometimes I've found myself probating estates that are years and years old just to be able to eventually sell the house down the road. Social Security numbers, again, the original will, if any. We talked about the inventory of assets and known liabilities. Red flag moment here, again, really, really pay attention to how things are titled. Going back to what we talked about, 2 ways to pass property at death, will or will substitute. Is it in the decedent's sole name? Yes. Part of the executor, the fiduciary's responsibility. No. You're going to give that asset to the named beneficiary joint owner, give them a death certificate. It's their job to collect. Also with this inventory, it's going to give me an idea, do we have to file an estate tax return? Have we met the filing threshold? Again, very different from saying, are there taxes due? So please, please do not make that big mistake and say, oh, well, no taxes are due because everything is going to the surviving spouse or to charity or whatever, and we don't need taxes. It is not based on taxes that are due. It is based on the filing threshold. Now, there is people, oh, I don't want to pay for that. What a waste of money. But estate tax return is a huge pain and it's expensive and time consuming. That's true. But there is a benefit for you guys. And that is called the step up in basis. Very, very, another big red flag moment. So when somebody dies, all of their assets are going to have a step up in basis at death. Technically, it's called an adjustment in basis at death. Most assets have gone up over time since the decedent bought it. But in case things have gone down, like you have a lemon of a stock pick that you did, your cousin told you about, you got it, and it was a stinker, that will be readjusted to the date of death value, which would be lower than what you purchased. So when you file the estate tax return, you're going to record the current fair market value of the asset, and there'll also be a basis form that'll go along with it that will go to the beneficiaries, and that'll be your proof for the new basis, so that when you sell the house that, the house in the Hamptons that grandma gave you, or the condo in New York City that she bought for $40,000 is now worth $2 million, and you sell it next year for $2.1 million, your capital gains will only be on the increase between the date of death value and the date of sale, just because the basis steps up at date of death. One exception, if I was here in the audience to say, does anybody know what the exception is? The exception to that rule. Don't see any virtual hands out there, so I'll just have to tell you, our retirement plans, you do not get a step-up basis in retirement plans. No one escapes Uncle Sam's income taxes because you, the decedent, didn't pay income taxes on their retirement plans. So when they pull it out, they'll pay income taxes as they pull it out. Roths obviously have their own set of rules. Roths are no income taxes when you pull that out. But you know, your IRA, your 401k, the traditional ones, they do not, as you pull it out, you're going to pay income taxes, and you'll be getting a 1099-R from the financial institution telling them what part you have to pay. And another factoid is that is going to be taxed at your highest income tax rate. It just is going to be piled on top. Okay. You are going to need the most recent statements. Okay. So I asked people recent date of death, try to get me the statements from the financial institutions for my brokerage account, my IRA, my bank accounts, that has the date of death value in there, because that is I'm going to need that for my basis calculation and also to figure out if I have an estate tax that is due. Okay. I'm also going to ask for 3 years of income tax returns and any gift tax returns filed anytime during the decedent's lifetime. The first one, the income tax returns, will be like, wait a second, why do you need that? Well, one of these days I got to get myself a Sherlock Holmes hat. You know, looking to see what the assets are. My income tax returns are my source of clues on what assets are out there for me, the fiduciary, to collect. So I'll find them. I see I see interest, dividends, K1s, partnership, closely held businesses. And I like to look at the last 3 years because accountants are people just like us, and they can make mistakes. An accountant may not have gotten a 1099 or an interest, or one of the got the information and may have forgotten to record an interest or a dividend, or maybe there just wasn't that year and there still is an asset out there. So I like to look at 3 years of 3 years of income tax returns, see if there's been any change in the assets to help me identify what assets that are out there that I haven't collected. Gift tax return. If you're filing an estate tax return, you are required to give all the gift tax returns ever the decedent has ever filed. So that might be tricky because people throw things away. So what you have to do there is you have to write to the IRS, ask them for all the gift tax returns that have ever been filed. They'll give you a list. Then you make a second request asking for the particular years that you need. Okay. Then you're also going to ask for you to bring life insurance information, including the original policies, the homeowner's insurance policy, and renters, and any riders. So why do we care about that? The life insurance, we're going to see whose responsibility is to collect it. Typically, life insurance, you say, wait a second, Jill, like life insurance, isn't that typically a will substitute? Isn't that typically supposed to be the beneficiary's job to collect? I go, yes, that's right. But we can change a will substitute property to a probate property by making the beneficiary the estate of the insured. And indeed, sometimes in my estate planning, if I do not have a taxable estate, I will tell my young married couple, why don't we name the primary beneficiary each other, or maybe we'll just name the estate, so that way we have the ability to do some of the tax planning for the optional tax planning for the surviving spouse with the disclaimer trust, and more importantly, if something happens to both of them, that money is going to be put in trust for the kids. So we're going to take a look at the life insurance. Homeowners policy, what are clues there? The clues there are, especially if there are any riders, are there any valuables? Okay. Rolex watches, diamond rings, art, antiques. If there's a rider, I'm going to want to make sure those things are in the apartment or the home, that hopefully they did not grow legs, shortly before the decedent died or afterwards. If that does happen, we now have information which we can file a claim. Safe deposit boxes. Let's see if we had that and who had access. A tip here is that when anybody's doing the safe deposit box, try to always add another person on there. So when the decedent dies, they can't seal the box. You're going to have all your bills and expenses, stock certificates, the deeds for homes to see who owns them. And we also want to get the details for the accountant and insurance agent. Trust agreements, if there are any, especially if it's a revocable trust, we're going to need it. And our family tree. Our family tree is going to help us decide who our heirs are and who need to do, who are interested parties. Okay, so now we're going to talk about commencing a probate proceeding. And by the way, guys, I know I've been doing a fair amount of talking. If there are any questions, Avi, any questions in the chat box?
So far, no. Feel free, as we said in the beginning. And I will stop you here for a second. Actually, good timing. Segue for code number 1 is Empire State. Everybody, make sure to write it down. The Great Empire State.
All
and
right, well,
any questions?
Yeah.
Feel free to hit the chat.
Yeah, let's pause for 5 seconds. Anybody have any questions on the material we have already covered? Anything coming?
So far, no. I guess.
Okay, I'm so glad that.
Learning it very, very well. You're doing a good job.
Oh, good. Either everybody's paying attention, or they're shopping on the internet. I don't know. Okay.
Or they're shy. Either way.
Yeah. All right. So now we're going to commence the probate proceeding. We are going to identify the appropriate domicile. Well, the decedent lived in New Jersey, moved, had an accident, and was in a nursing home, was there for a little bit, then was sick, rushed to the hospital, and died in the hospital. Where do we probate the will? Okay. All right. Oh, we have a question.
We have a question from Murray Bonenfeld. I think I pronounced it well, I hope. What insurance update is needed?
Okay. So when we have when our decedent dies, and this is most important when the home is vacant, if the person had a homeowner's policy that protects property from flood, fire, personal property, we're going to want to call the insurance company and let them know the home is vacant, because it is a greater risk of problems when there's a vacant home. So we want to make sure that they are known, and then they convert the policy, that you let them know that it's now an estate policy. If there was no policy, as an executor, I tell my clients to talk to your insurance broker and buy a policy. So that's very important. Again, if you're personally liable as the fiduciary. So, you know, if the person didn't have a policy and there was a theft or a flood and there's no insurance, you, my friend, can have a problem. So let's not have that problem and be on top of that. Okay. So we're going to, the decedent's domicile is where.
Oh, another question from Kenneth. This is a question on the insurance on an estate. Is this insurance even if the decedent had no property? Where do you get this insurance for an estate?
Okay, well, so your typical property and casualty broker can help you. That's who I go to. And it's very rare. I mean, let's say that the person, you know, they have something, unless it's a bit of a risk. Oh, all that stuff is garbage. Well, you know, there's been a couple situations where I've had an estate where we thought it was garbage and we found a painting that's actually worth something. So you're not the appraiser. Also, you're going to have if you own the place, you're going to want to have at least flood and that kind of insurance as well for fires. If you're a renter, then obviously that doesn't count. Then it'll just be the contents that you're concerned about. We have another question.
Scott Inwold is asking, does the executor have to file tax returns for the decedent?
Oh my gosh, that is one of the most important duties of a fiduciary. So your executor has to file the decedent's final income tax return. And if they haven't filed their income tax returns the last couple of years, you're going to clean it up. So there are two tax returns, possibly three that we're talking about. One is the estate tax return, if you're required to do that. Two, income tax returns, you got to cure it and get that done according to the regular filing time for an income tax return and going on extension. And if the decedent had made some gifts and didn't do the gift tax return, you're going to be doing that as well. Yep.
Lisa Fantino is asking on Roth accounts. I assume Roth IRA is asking the banks. Yeah, RTH. I think that's what she meant. Do banks and brokerage typically allow named beneficiary to be estate of?
I don't see why not. You have the freedom to do that. They should have no problem allowing anybody to be a beneficiary, but I'd have to check with the financial institution. I mean, typically we generally want to name an individual for retirement accounts. We generally want to name an individual anyway, as opposed to an estate, because the individual has the ability to potentially stretch out the IRA. Like it's been significantly curtailed since the Secure Act with the 10 years, but there are exceptions, and I have a whole conversation on that. But if you
she's asking here, sorry to interrupt, but I think she added a question about Roth IRA right of survivor.
You mean right of survivor?
Right, that's what she wrote. Lisa, if you want to clarify what you mean.
Well, with an IRA, you name a designated beneficiary. So it's not like a right of survivor. You just name a primary beneficiary and a secondary beneficiary. That's what you do. And you want to generally name individuals, because if you name an estate or a trust, then you're going to terminate that account and have it all paid over. Now, with a Roth, it's not as much of a problem, because there's no income taxes due, and that may make sense if you want to put everything. You may want to put everything in a trust, but for retirement accounts that have income taxes built in, then that's going to accelerate the income tax.
Sorry, Lisa, just clarifying. She's asking about bank accounts beneficiaries or non-retirement brokerage accounts.
So yeah, for bank accounts and brokerage accounts, you name beneficiaries. You can have POD, payable on death, TOD, transfer on death, or JTWRS, joint tenants with rights of survivorship. So let's continue now.
One more question.
Okay.
Sorry, before you go, and then you can continue. Scott Inwald is asking about the time frame. What is the time frame for letters testamentary for a non-taxable estate?
Oh, well, I'd have to get my magic 8-ball. Let's see. There we go. What is the time frame? You're out of luck. I have no idea because the courts are backed up because of COVID. So there's a little dramaticism here, but no, I wish I knew. It is really backed up. I'm telling people months. So typically I'm now going for preliminary letters at the same time, and I give a sense of and I give a specific reason for urgency, like we're selling the home, or we're concerned about a volatile market, and we need to get a hold of the brokerage account before we have that market correction that everybody's concerned with. But we're talking months. I had one estate that I filed in the summer, and I got letters in November. I mean, there were no issues with it. It is really anybody's game. Really, really problematic. If you can, I would call the court where you're going to be filing and see if you could get anybody to answer the phone. And if you do, you can ask them, hey, what are we looking at for a turnaround time? And maybe they'll say, I don't know, or they'll hang up on you, or maybe they'll actually tell you something. I think maybe the best, if you can't get it that way, you'll speak to a colleague that's recently filed that practices in that jurisdiction and say, hey, what are you seeing for the turnaround time in New York County or Kings or way? It's unfortunately, that's the way the world is. And that's why I'm moving a lot of my clients to revocable trust, which is to avoid probate. All right, let's continue about commencing a probate proceeding. We are petitioning for our letters testamentary. And we talked, now we're going to have our probate petition in. We're identifying the heirs, okay? And we may want for preliminary letters, especially now, okay? Especially because everything is backed up. And with preliminary letters, you can do everything that you can with permanent letters other than paying monies to the family, the gifts. So you can sell the house, you can collect the bank accounts, you can file the income tax returns, you can negotiate the debts. You just can't give the monies to the family until permanent letters are issued. Permanent letters issued are when the probate process is complete, which means we have gotten jurisdiction over all of the heirs, what's called the distributees. And the distributees under New York are people that would inherit if there was not a will. And you need to get their waiver of consent. A classic situation is, say, somebody is a single person. They have they're estranged from their family. They haven't spoken to their sibling or their siblings' children or their parents in years, or maybe their parents are now gone, and they want to leave everything to charity or to their friend. In this case, you have to then find who those people are. Even though you can legally disinherit people, the only people you can't legally disinherit is your surviving spouse. They're entitled to elective share, but that can be waived through a marital agreement or just an elective share waiver. You need to find these people. And then once you identify them, if they're the heirs, you have to, in order to get jurisdiction, you need to send them a waiver of consent. And the way that works is you get a copy of the will that says you get nothing, and a piece of paper that says waiver of consent saying, please waive your rights to the will and have your signature notarized. Please take time out of your busy schedule and expose yourself to COVID and find a notary and sign in front of the notary and do me a favor since you're getting nothing and send that to me. So you can imagine that very often people throw that stuff away or blow you off. So what you have to do then is plan B. And plan B is a big pain in the butt. You have to then go to court and say, I need to get jurisdiction over these heirs, and I'm going to ask you for a citation. And the citation is going to say, it's basically an invitation to a will contest. And it has to be served. And how it's served will be based on where that distributee is located. If they're located in New York, they'll be personally served. It means you're going to hire a process server with the waiver and consent, with the citation and the will, knocking on the door, saying, hey, is this Avi Azule? Here you go. Here's this citation, and I'm out of here. And then they'll basically say, dear distributee Avi, you on such and such on March 15th at 10 a.m. You are cited to show cause before this court why this will, which I just gave you a copy of, should not be probated. You do not have to have a lawyer, do not have to show up. And if you don't show up, your rights are waived and the will goes. If you do show up, heirs have the unique rights of causing problems. And that's where green mail comes in. So this disinherited child or disinherited sibling can come in, even though they have no relationship, has not spoken, can say, even though they haven't talked to me in 30 years, and even though I'm a jerk and all this stuff, I have the right to make sure that my dear sister didn't make a mistake in disinheriting me, even though we've had no relationship and she hates me and I hate her. So I have the ability as a distributee to depose, what's called 1404 depositions. I can depose the witnesses to the will. I can depose the executor, and I can depose the attorney draftsman. And you know what? And the estate gets to pay for it, and the estate's delayed. So what happens is the green male is the disinherited brother will say, you know what? I know I can hold this thing up for a very long time, and I know you have to pay for producing these witnesses and paying for this transcript, and it doesn't cost me anything. And I don't even have to need a reason. No reason at all. I just can go on a big fishing expedition that's on your tab. So I'll say, you know what? Write me a check for $50,000 and you have my consent. And that's how that kind of thing works. Hopefully you get everybody to waive and consent. And knock on wood, I've actually had a very good track record on doing that with basically saying, look, you're really hurting other people, and especially if it's for charity. And the only people that get rich are the lawyers, which no one ever wants the lawyers to get rich. And sometimes for a little icing on the cake, I will send them a Starbucks gift card for their trouble of going to the notary. And so far, I haven't, knock on wood, I haven't really had to cite too many people. Now, if they don't live in New York, you're going to have to then serve them by certified mail return receipt requested or by Federal Express. If they don't sign the paper or sign the postcard, you then have to go back to the will and get a supplemental citation for like what's called mail and mail, regular mail. Bottom line, try to get everybody to consent. If you know you are looking at this problem, like someone is estranged from their family, that is a big red flag to go to avoid probate and do a living trust plan, or have all the assets with beneficiary designations. Really, living trust plan is the way to go. You have no relationship with your family, do not go to probate, do not go and do not collect $200. Do everything through will substitutes. Do not have to spend your estate and your family or whoever you want to give to, spend time and money and finding all these people who you want to have nothing to do with, and get their rights waived, really. So we have the waivers of consent. Again, that is going to be based on who the heirs are, based on who died. And that's, again, you'll find that in EPTL 4-4.1, which is the intestate estate, the intestacy statute. Now, you're also going to give people notice of probate. And what's a notice of probate? If you're not an heir, you're not a distributee, you're just getting notice that the probate is happening. And what that is a successor executor, a successor trustee, also someone that's gotten a specific request. So I gave $10,000 to American Heart Association. I gave my diamond ring to my niece. So those are the types of things you're going to get a notice of probate with. Other documents, also you can give notice of probate to the Attorney General if there's a charity involved at all. So that's something that that's a commonly overlooked point. If there's a gift to charity at all, we're gonna give a notice to the AG, and they have a box there at the court. You drop it in the box. Other documents you may need. Remember that terrible affidavit of Staples that hopefully none of you will need to do because you have listened to this lecture and you'll tell everybody never to unstaple your will. But you may also have what's called a kinship affidavit, which is this affidavit of sole distributee. Remember how I mentioned that, say, someone is married and have no children? Well, in that case, their only distributee, their only legal heir is the spouse. And New York law requires that in the case that there's only one distributee, then you need to find a person that knows the family that you can prepare this affidavit, that says, I've known this family. This person was married only once or was married twice. They've had no children, or that either were born or died, and this is the sole distributee. So you will have that kinship affidavit or sole distributee. So we'll also those are the two main documents. Also, an affidavit proving copy of a will. We have a question.
Sorry, I was muted. We have a question from David Cotner. In what circumstances do you give notice of probate to the public administrator?
You will. Those are called. That's under our administration, but we have a couple reasons. We'll notice the PA. Most recently, I had to notice the PA where we had a will, but we had unknown distributees. So because she was the stepmother left everything to her stepchildren and disinherited her family, and so we had unknown distributees, so we had to cite the PA there. Also, if we have what's called a cousin's case, if the closest living relative is going to be a cousin. And in an administration, if the closest living relative is a cousin, the public administrator is going to be the one that's going to administer the estate. So that's pretty much. There could be other reasons, but those are like the main ones that I've encountered. And sometimes I will say, I will bring the public administrator in. You'll see this also. Say we have a situation where the executors are not doing the right job, or someone is stealing and they're before the court. I've seen this happen where, like, okay, both of you are out, you can't get along. We're putting the public administrator in, and they'll do it right from the bench. I've seen that. Actually, the one story that I did see is there was a will, there was a probate proceeding, and there was some controversy going on, and the executor filed for letters of testamentary, and she left out her sibling because she was estranged and didn't like her. Kept the other siblings in, but left that person out. And then that missing sibling showed up and say, "You need to add me." And the court was so angry, they removed right at the bench. "You are out, you lied," and the public administrator's in. So that is an example. Okay. So we also, let's talk about special situations, charitable beneficiaries or disabled beneficiaries. So if we have charitable beneficiary, more specifically, if it's a residuary beneficiary, not either all or part, the Attorney General is going to be involved. You're going to be accounting the Attorney General, so it's good to have a good relationship with them. If there's a disabled beneficiary, we're going to have a guardian ad litem appointed for that heir. And the court will appoint them, and because they can't waive the consent, and then they'll have to do a report, and the court and the estate will pay for that. We have a question.
There's a question from Lisa Fontino. Is it a good practice when there is an only child to have parent testator have a relative or friend with the knowledge of family history provide kinship affidavit upon signing the will?
Well, you don't really, you could certainly have notes to the file, but who knows when the person's going to die. And I don't know if the court would take an affidavit from somebody that knows the person and then they're dead, because by the time they're gone, the person that signed it, it's like 10 years old. So that's not something I've ever seen. I think I'm not saying if it would or would not work, but just as a practical matter, you file something where the person knows the history, at the time the decedent died, because say, you know, you would say the person, you know, didn't have any children, but maybe they adopted a child 10 years later. So you really, I think you really need it familiar with at the time of death as a practical matter. Okay. So also let's talk about non-resident decedents. Okay. We have a decedent that had a condo in New York, but they lived in Florida because they want to avoid all the nasty New York taxes. So what happens here? Well, we have our original probate where the person's domicile is in Florida. And then once we have the probate done there, we have that probate then respected over here. And that's called ancillary probate. Ideally, if you are living in Florida, you know that Florida is a terrible probate place, and you'll have everything in a living trust, and you'll know you have a condo in here, and so you would have your condo in the name of the living trust. You would avoid ancillary probate to begin with. But for those that don't, the way it works with ancillary probate, you look for where is the decedent's state of domicile. You probate your will there or your administration there, and then have that, get exemplified copies, and then have that brought here in New York, and then have that recognized here. And that it can also be done internationally, by the way. So I do a lot of international state administration. So when I've had someone die overseas, we have the original probate or whatever they consider probate done there, and then have that recognized over here. And then you have a lot of times translations and lots of seals and apostilles, but it's the same process, but a little bit more complicated. Okay. So anything else about probate before we now move into administration? Okay. One other important point I want to mention, and that is the attorney executor disclosure statement. And what is that's the also called the Putnam affidavit. And what that's about is that it is, this is pretty much unique to New York, where we have a situation where the attorney draftsman is also serving as the executor. So the client comes to you, they'll say, Avi, I don't know anybody, you know, I'm estranged from my family, or I never married, I've never had any children, I don't have any siblings, I don't have anybody. I want you, I'm making you the lawyer now. I want you, Avi, you're gonna write the will up, and I want, I've known you for all these years. You're an honest, organized, smart person. I want you to be my executor. So you're gonna draft a will for me, and you're also be my executor because I want to leave everything to charity. In that case, you're gonna need what's called an attorney executor disclosure statement. It's found in the Green Book, in the PTL forms. You can also probably find it online. And what that is a statement that the client needs to sign and have it witnessed. And it has to be witnessed by someone that's not in your firm. And it basically says that it's a disclosure that when you have an attorney executor, they're entitled to 2 fees because they're wearing 2 hats. They're entitled to an executor's commission, which is commission under state law. It is a numeric calculation based on the size of the estate. And then because they're also hiring themselves to be the lawyer, they're going to be entitled to a legal fee. And if you do not sign that attorney executive disclosure statement, the commissions are cut in half. So it is a big motivation to make sure that you always have your attorney executive disclosure statement signed. And this is another pitfall. Say you sign it and then they come in and they update their will 2 years later. You need to have them re-sign it. You need to sign it each time. Courts are always looking for a reason to cut your executive commissions in half. That being said, if you are unhappy with that, you, like any other named executor, can say, no, thank you. No good deed goes unpunished sometimes. Being an executor is a thankless job, and you could say, I don't want to do it, I decline. And that is your choice. That is why, and this is also a big red flag moment for any of you. So all of you guys are lawyers. I could ask you who here has done their own estate plan or has an estate plan. Some hands up, some hands, oh no, I need to do it. Thank you for reminding me. But it's important that whoever, the plan that you have or the plan that you may do one day, or the one you have and you want to make sure it is still up to date, the people that you have named as your executor, as your successor executor, as your trustee, as your guardian, as your healthcare agent, as your agent under a power of attorney, they're all good to go and on board. And there are appropriate people for that role. Okay. That's actually a whole unit that I talk about at Cornell Law School when we're talking about the estate planning clinic, is making sure you choose right. And I actually have a separate seminar that I do on how to choose the right fiduciaries, because half my business is estate and trust administration. And I cannot tell you how many times where people have chosen poorly. And it's just the ripple effect that it causes is really awful. If someone had just taken pause and really gave it a good think, who should I name? I'll give you two little example stories that'll hopefully resonate, and maybe if you were there, someone you could have given your own stories. One, we have mom. Mom has two children. Mom is naming both those children to be co-executor, even though mom knows that the two children do not get along and have really big problems with each other. Maybe they aren't speaking with each other. Guys, this is not the time to get them to reconcile. Unless you want to make the lawyers rich, do not name both of those children to finally bridge the gap and act together and rise to the occasion. They basically go, not rise to the occasion, but it becomes a race to the bottom. And, you know, the lawyers get rich. So do not do that. So what do? A solution is you try, what I recommend, because the kids will hate each other, is name a neutral party. An accountant, I love naming the accountant. The accountant not only knows what it means to file income tax returns and can do the decedent's file income tax returns, but they understand about paper, assets, you know, details, responsibility. And I know the family and the assets because they've been probably working with that family for a while. So you will get a neutral party. Other neutral party could be a corporate trustee, like the Obvious Bank, especially if they can do that. And sometimes maybe even the attorney that's a draft person like me. I generally say I'm the person of last resort. I do not want that job. But if you have absolutely nobody and you've interviewed your banks, your trust companies, and your accountants, and they still are no good, I will do it. So I won't let anybody be abandoned, but I do not want that job. So that is one example of choosing well. Another two examples, and yeah, these are, you know, big red flag moments, and it's more to do with estate planning, the state administration, but these are just so important because I've seen in the state administration, this can create major, major ripples. I have a situation where, you know, where you are naming, like you have your healthcare agent, and the person is in the hospital and they're sick and they want to put them on hospice and they're in the end stage of their life, and the person they name is their healthcare agent. It is against their religion to enforce a living will. And then of all the other families knows that this is the person did not want to have their days ended in this manner. And they had signed a living will and they say, please, I do not want to do this. I do not want to be this way. But the healthcare agent is against their religion. This actually happened in my class where the student said, Professor Miller, I do not want to be part of signing the client's healthcare process living will. This is against my religion. Said, well, this is their choice, not yours. Said, nope, I'm not part of it. Okay. So really make sure that the person you name as your healthcare agent is the right person. Okay. They will follow your wishes. Another example is the naming of the trustee. And in my estate administration, the trustee is living, you know, is living in Hong Kong. Really not a great place to be if I need them to be acting here and now and interacting with the beneficiaries. So, you know, really think carefully about who that could be. That's why you update your plan every 5 years, making sure the people are current and make sense. All right. Enough of the little estate planning bonuses. Any questions, Avi? Okay. All right. Now let's talk about estate administration. This is where really the intestate estate, where we talked about a probate petition and a proceeding for probate. That's where we have a will. And the way I remember, you get letters testamentary, because I think about last will and testament. Where there is administration, there is no will. Someone died without a will. So we're going to have to petition for letters of administration. And then who gets it? And if you think about it, it actually makes sense that the persons who are entitled to petition for to be the administrator of the estate follows in line with who the intestate heirs are in the order of priority. So, for example, if there's a spouse, if the husband dies survived by the wife, and he had no will and he has children, the wife is first priority. If there's no wife, then the children are first priority, and it goes down the line. If there's no spouse and no descendants, then we'll see the parents. If no parents, then we'd have siblings. So if we have multiple people like parents, they can do it together, or we can pick somebody. It sometimes becomes more dicey if we have multiple children, especially if we have people that don't get along. And that is a great way to increase legal fees if we have 3 administrators, and then I have 3 phone calls. So I say, look, guys, get together, figure out who the point person will be, and let that point person then just share all the information. Hey, I don't mind having the same question asked to me 3 times, but I sell my time, not my good looks or my jokes. So, don't be upset when you get the bill. So I try to, again, managing the client's expectations, and they'll appreciate it. I'll be like, thank you. When you have administration, you're going to have a bond that you have to deal with. The bond is to securitize the administrator's actions. They'll ask you what kind of debts, was the funeral bill paid. It is a form of insurance. You have to then call a bonding agency. It could be a couple hundred to a couple thousand, and you have to have it in place until you're done with the estate, and you then ask the bond to be discharged. What I generally do is I try to get it waived by the court. So I make sure my funeral bill is paid. I make sure all the beneficiaries waive the need for a bond, because it really is a bunch of wasted money. I've never, ever in my entire career ever needed to call on the insurance bond anyway. That's why in your most basic will, from the 3-page specials to the ones that a specialist like myself would draft and prepare, I always say the bond is waived. All right. So then we're going to find out who are the beneficiaries. And that's we're going to look at the intestacy laws 4-4.1, and the petition for administration will say who gets what share. And that's again right from the intestacy laws. So let's just now take a look at a sample probate petition. Just to just pull that out, let's do like a little quick tour before we go on to some of the estate administration tasks. As another tip or trick, I use, and many practitioners use, in the New York State Bar Association forms. They're the forms that are used for every single court. So if you use those, presumably you'll have no problem having them bounced. You'll look at the top here, and it says petition for probate and what? So you're always going to at least have letters testamentary, because you always need that. Letters of trusteeship, that is if there's a trust under the will. Typical trusts are my credit shelter trust, my trust for minors, my Q-tip or marital trust. Letters of administration, CTA. This is a really interesting one. You're like, wow, why is there, say, administration if this is a probate petition? Well, this is a funky little thing that happens in a very rare while, where we have a will and the people that have named as the executor decline, or there's just no executor. So then what will happen is the beneficiaries will designate who is going to serve, and they'll get letters of administration, CTA, which is a will with, you're actually probating a will, but the beneficiaries are going to be naming the executor. And I'm doing one right now. So I had a situation where the decedent left everything to charity, named a friend and the friend's wife as the first and second executor. and neither one of them wanted to do it. They said, no, thank you. And then the charity designated me, and now I am the administrator, CTA, doing the work. Okay, petitioner, that is saying who is petitioning for who's asking to be the executor, has their basic information. Things to think about here are they a lawyer? And is the executor is or is not the attorney draftsman, or an attorney or an employee? So you have to have special extra paperwork if you need to put in. If they are a lawyer, you put in that, you have to put in whether they drafted the will, whether they're serving. It's a special extra piece of paper that you have to deal with. I see this where I have the petitioner is a lawyer, but they're not practicing in trust and estates, and they'll say, I'm a lawyer, I did not draft this will, I'm not acting as the attorney for the executor, and Jill is going to be the estate, and I'm not, so that's how that works. I'm not taking a legal fee for that. And then comes in, you talk about the decedent's information, the witnesses to the will, and then the second page has a list. The decedent was survived by distributees classified as follows. And you see a list there: spouse, children or an issue, mother, father, brothers and sisters, whole or half blood, predeceased, grandparents, and then all that goes down to first cousin, 1, 2. This dovetails the intestacy statute. So basically, you're going to put in, a number or an X, yes, really, yes, spouse, 2 children, and then anything below that you'll X out because it doesn't apply. Something that's an interesting fact here is that half bloods are considered the same as whole bloods, and so included are adopted children. So if you found out through ancestry.com that your father was a wild man in the 1970s, and you have 2 half siblings out there, and you know about it, guess what? They are now part of the child box. So, and then just a couple other points here. You're going to have your 7A people. Those are the notice of probate, successor fiduciaries, people that have gifts. You're going to then talk about the size of the estate. I always do estimates. And then you're going to have the oath and designation that's going to be signed in front of a notary, whoever's signing is the executor, or saying I'm going to do a good job. Okay, this is just a little highlight of our probate petition. Before we move on, Avi, do we have any questions?
We are no question. Anybody?
Before we move on from the probate petition. Okay, great. All right. Now let's talk about. Oh, and before I forget, Avi, what time? So I'm respecting everybody's time here.
To respect everybody, exactly 10:40 we'll finish.
At 10:40. Okay, great. All right. So let's talk about this. Now we've got our executor appointed. Avi, you're going to be my tried and true executor. And now you need to know what to do. What do I do? Well, that's where I get to the checklist of people and places to call in the death of a family member. Those are things that'll help you, what to do and not do, who to call. You don't have too much time left. We will, talk about, just look at that on your own. But some of the things are, you're going to be able to get the life insurance forms. You're going to, life insurance forms. You're going to, speak to the insurance companies, securing the apartment, taking care of the utilities, Social Security, getting an accountant. Those are going to be helping you with getting your basics in order for your state administration. So we have our newly formed executor. We're going to get a taxpayer identification number, a TIN. So you're going to get so Avi, you're going to fill out that SS4. We're going to get a Social Security number or a taxpayer identification number for an estate. So an estate is a legal entity. It needs its own taxpayer identification number. It's their Social Security number, and you'll use that to open a bank account with Avi for the estate account. So that's how we're going to do that. Then we're going to be looking at the nature and the extent of the assets and liabilities. Again, going back to what we first talked about, how we pass property on the decedent's death. Those assets that we don't know where they go. There's no joint owner. There's no beneficiary. There's not in the living trust. That's going to be controlled by my executor. So I'm going to reach out to the banks and brokerage companies. I'm going to find out what I need to collect. I'm going to give them my letters testamentary. I'm going to open a bank account, and then I will then collect. I see there's a question about a taxpayer identification number. You are then going to go, you're getting it from the IRS. SS4 IRS. Okay. What's the other question, Navi?
Well, did you see the one about how do you get the TIN?
Yeah, we get the TIN by asking the IRS.
Okay, we're done. So next one from Grace Powers is asking, what happens if you discover probate assets after the petition for probate has already been submitted to the court and the said asset was not accounted in the original inventory or estimate that is given to the court? Do you need to file an update with the court?
You just need to collect it. Depending on how long it's passed, there's no court police. And these days with the inventory of assets in brackets, it's in brackets anyway, meaning like it's in ranges. So it's like over 10 or over 20. You have to just look at the different boxes. So I wouldn't worry about it. It happens all the time. You find a later asset and then you just collect it. So, and a key to that is abandoned property. Always look for abandoned property. That's one of the things we like to do. Okay. And you should check, by the way, the abandoned property periodically. Don't think it's one and done, because it kind of filters in over time. So especially if I have an estate that's been on for a few years, I'll check it a couple of times and I'll find things that pop up and collect. So, you've looked at your assets, the assets that have beneficiary designations or joint owners. They have collected it on your own. The estate, the probate assets you're going to collect. You're going to then see if there's a right of election. That is state specific. It depends on what state you're in. If your spouse is estranged, they're still entitled to the right of election unless it's waived. It's very, very hard to get around a right of election. I think there's a rule for abandonment. If that person abandons you, is a decedent, which is hard to prove. But basically, they're entitled to 1/3 of the estate. Okay. And now we're also going to look at for claims of assets. So there may be, there may be someone holding on to it. Oh, we have a question. Okay.
Quick question from Alan Katz. What is the monetary threshold of an estate when you should or must file an estate tax return if there is no estate tax due?
Okay. So like I mentioned earlier, the requirement to file an estate tax return is not, and I repeat, is not based on tax due. It is based on the gross estate. The gross estate is all of the assets the decedent had at death, which includes personal property, jewelry, timeshare units, life insurance, all of it, unless life insurance is held by the trust. It's not, an insurance trust is not part of the estate. So that is based on the current exemption amount, which is for federal $12,060,000, and for New York it just got raised to $6,110,000. So if your gross estate equals that, does not matter if taxes are due, you have to file. And again, like I mentioned earlier, you're going to get your step up in basis, so you can declare your basis. So that's going to be a good thing you'll give to your account. Yeah.
One more question. I'm not sure if you answered that already, from Elise Leibowitz. What assets are excluded from right of election?
Oh boy. Okay. So you have your spouse's right of election, and that's 5-1.1 capital A. A bunch of years ago, it was enhanced to get people to bring more money into the estate for right of election, because people were crafty using those will substitutes, assets that passed by operation of law, to disinherit or end run the elective share. So on 5-1.1 capital A will list all the things that get brought back in the estate. So for example, I think gifts within a year of death, any assets that pass by operation of law. So your life insurance. So one example I remember having a long time ago, I represented the nieces. The husband was married. I think it was a marriage of convenience a long time ago, but they were still kind of living as roommates, but they couldn't stand each other. They never had any children, but he had nieces, and he named all of his bank accounts and brokerage accounts, named the nieces as the beneficiaries. So there's no probate estate, and she got her right of election, and she's taking 1/3 of those will substitutes. So you got to look at that statute. And if you're out of New York, you got to look at each state is different. So the UPC, Uniform Probate Code, has a really different way of doing it. And that's based on length of marriage. I taught that at Fordham. But you really got to take a look at that state's laws. If you want to try to avoid the elective share, you can give gifts and that are old and cold, and you don't have any rights to control it. Like you can't give it away. Well, I give the house away, but I really have the right to live there. That's included. Okay. Let's talk about claims for assets. So that's kind of there's some practical issues there. So say somebody makes a claim in the estate, like credit cards are typical, or a landlord is typical. And here sometimes the system's stacked against you. Here's the fiduciary, the system is stacked for you. So if a credit card or someone files a claim in the surrogate's court, it's automatically deemed rejected, like I think after 60 days. So you don't have to do anything, do nothing, you can ignore it. And then their next step is they have to then bring a proceeding to have their claim determined. What does that mean? It means big bucks for them and a huge pain, especially now with everything backlogged. So no one will. It is extremely rare, and I've actually never seen it where the dollars were big enough for someone to actually file the notice of claim, and then after it's automatically rejected, then bring a proceeding to determine their claim. Usually people work it out, and it's just a matter of how much of a haircut the creditor will take. That's just the practical nature of things. We're going to collect and value the assets, and that is something that we need to pause on because it's very important, and there are a lot of different categories. So their easy categories are what Avi can help with: the brokerage account and the bank account. Your date of death value. Interesting for the brokerage account, it is not the closing value, but it's the mean of the high and low. And there are actual companies that will calculate our date of death value. EVP, Estate Valuation Pricing Systems. I like them. They're cheap, and that's who the IRS uses. And you just give them the statement. They give you your report, including interest and dividends that are included, and that's that. But there are hard to value assets like closely held businesses, like art and antiques and jewelry. So what do we do there? Closely held businesses, we will hire a business valuation expert to value the decedent's interest in these closely held businesses. Okay. For art and antiques, I will hire an appraiser. For real estate, I will hire an appraiser. Sometimes people say, "Oh, well, a broker letter suffice because they're free." Well, you get what you paid for. A broker's letter is not sufficient to establish value for an estate tax return. And in fact, if you do that and you file an estate tax return with a broker letter, you are raising your profile to get bounced, and not bounced, but to be audited. And that will be a very, very expensive lesson. So it's better to spend the $600 or $800 to have the piece of real estate properly valued by a qualified appraisal. Qualified appraiser, it does a qualified appraisal. That's like the long form with the pictures and the 3 comparable properties. Do not cheap out, because that can be a very expensive mistake for your client. Okay. So for antiques and coin collections, art, you're going to get an art appraiser in there for specific pieces that are very valuable. You need to file follow more special rules and, have certain pictures taken and have it documented, because that could potentially go to the audit panel, the IRS. Yes.
A question from, excuse me, David Kotner. When are creditors foreclosed from making a claim against the estate? Are government agencies foreclosed as well, like an IRS or Medicaid?
Well, Medicaid will find out generally when the person dies, because once you file a petition, they're going to know, and then they'll send you a letter. But there's a 7-month creditor period, but it doesn't cut off creditors' rights. It cuts off the fiduciary's personal liability. So generally, when you have an executor, you do not distribute money to any of the family members until after the creditor period is ended, which is 7 months. If you do, Medicaid can come after you personally. So as far as when do the creditor's rights expire, I think we have to look at state law. I think it depends on the type of claim, whether it's a tax claim, credit card claim. But generally, I've just negotiated with them. We figure it out. They let themselves be known, and we figure it out. And we usually get a discount. That's what because it's not worth it for them to file a petition. It just isn't. It is too expensive and too time consuming. So at least you get a discount for the time and lawyer and delay expense and time value of money. So we have okay. Oh, yep.
Another question from Elise Leibovich is, what is the typical percentage of discount?
Well, it depends on what the creditor is. I will say from my experience, the longer I wait to pay a credit card bill, the more flexible they are to take what I offer. So, say offer 25%. And they'll say 50, and you'll say, okay, you got a deal. So there's no hard and fast rule, but I always, whenever I'm thinking about negotiating claims, I always know that I don't want to negotiate against myself, meaning that I don't want to start off with what I'm willing to settle for, because we always try to, I always think about meeting halfway. It's like a rough justice. It's kind of like the natural law of negotiation, right? You kind of always, no one should ever expect to get what you ask for initially or give. So we always kind of meet somewhere halfway on that. But with the credit cards, the longer you wait, because they have rubrics, I think, of how much they're allowed to settle for. And if it's gone on like a bunch of years, they're happy to get $5 in. So again, you just test the waters. The worst they can say is no.
I'll just take a moment here to tell everybody that our second code is Hudson River. The first one was Empire State. Empire State was the first. Again, the Hudson River is the second. You would need it when you log out, and I wrote a note for everyone. Where is the tab to get the certificate?
Okay. My last point on this section is you're going to file your inventory with the probate court. So at the end, that is your last roll in New York. They don't even give you an acceptance, you just file it. And there are, you check different boxes. It'll say based on the types of assets. And there's also, if there's any firearms, you have to kind of mark that. And you file it, and there's that list is what I usually do. In the past, people have also filed the estate tax return. I don't do that anymore, and I don't suggest that because the court list is just so easy, and there's less specific information. And with the probate file being public knowledge, and now that everybody's doing by e-filing, I don't see any benefit. In fact, I only see big downside of giving more information than less about your clients' and families' assets. In fact, that is another reason why I have moved more towards irrevocable trust. With the advent of the internet and e-filing, all of this is public knowledge, and there are companies that go in to the probate courts and just scan all the files and get everything that's been filed because it's public knowledge. And then they use those to make lists and they find people. They try to, I get, once I file a new estate, I always, get solicited by brokers wanting to see if my decedent, my family wants to sell. Anyway, you guys have been great. Thank you for all of your questions. And it was a pleasure.
Jill, I want to thank you so much, as usual. Awesome presentation. I hope everybody enjoyed. Just again, to remind you all, there are instructions that I typed earlier where to receive your, how to print out your CLE. It's pretty simple. The guys in attorney's credits are awesome. As you know from before, they're available on email. If there are issues, feel free. They will respond pretty fast. And thank you again. And we hope to see you, what do you say, Jill, in person soon?
Yeah, I would love that. And
maybe very soon. I don't know. Let's pray. Everybody stay safe, healthy, most important. And we'll see you all very, very soon.
yeah, and I hope everybody remember there's 3 things in 3 months' time. And if you didn't download the handouts, take them and use them and share them with anybody you know that you could help.
Absolutely. Thank you, Jill, again. Thank you, everyone. Have a great and safe rest of the week.
Bye.
See you soon.